Welcome to this presentation covering sexual orientation and gender identity discrimination. Let's begin. So we have 4 topics to cover in this. First is a little introduction, a little bit about terminology. Then we'll talk about our first topic, which is sexual orientation, employment discrimination. We'll talk about same-sex sexual harassment, a topic that we covered a little bit in a previous module. And then we'll talk about gender identity employment discrimination. So let's begin. So sexual orientation, the definition that we're going to use is the category of individual one is attracted to for romantic and intimate relationships, adult type relationships. A common term that is used for this to describe this area is LGBT, and that stands for lesbian, gay, bisexual, transgender. Sometimes there will be additional letters that are provided, and sometimes the symbols, especially the plus sign, indicating that this grouping can be more, have more facets than just these 4 categories. Other terms that we often see are the terms gay and lesbian. Gay is usually reserved for male homosexual individuals, and lesbian is usually reserved for women who have same-sex attraction. Bisexual obviously was referring to individuals who are attracted to people of both genders, and we'll talk about transgender in a little bit more. There's obviously more granularity that we can get into, but for our purposes, I don't think that it's going to be necessary. Obviously, sexual orientation has been a controversial topic in our society, and by extension, in the workplace. And it can raise a lot of issues about different values people have, sometimes people's religious perspectives on these issues. Generally, though, personal beliefs and personal points of view should not affect the way that we interact with people in the work environment. We don't have to agree with the choices that a person is making in his or her private life to treat that person with respect and dignity, and to give that person the same opportunities for advancement as somebody whom we happen to agree with about their personal life. There can be a conflict, though, when we're talking about somebody's religious beliefs. So if you have 2 workers, one who is part of the LGBT community, and then another person who has a religious belief system that is not consistent with support for the LGBT community, navigating that area, because both individuals have rights under the law, and so navigating that area can be tricky. Right now, we don't have a lot of answers to that, so I'm not really going to talk about it in this presentation. We'll have to see how the case law develops. But just be aware that both the religious person is entitled to protection of his or her religious beliefs, as well as reasonable accommodation of those beliefs. And the member of the LGBT community is entitled to be free from harassment and from discrimination based upon his or her status as a member of the LGBT community. So it can be quite tricky to navigate that area. If you in your professional life encounter that situation, you're going to want to do a deep dive into whatever the case law is at that particular time. An interesting difference between sexual orientation protection and things like race or national origin or gender is that you cannot hide, one's race, or at least in most cases, people are not able to hide one's race or one's national origin, and typically one cannot hide, at least not easily, one's gender. But usually a person is able to hide one's sexual orientation. And so because it is a characteristic that is not visible and is something that sometimes people have an evolving view of. So what may have been their view of their sexual orientation at one time in their life may be different than what it is now. So it's not necessarily static. Although I don't want to suggest that this is something people can change, like they change their hair color or something along those lines. It is an important part of many people's identity. So the fact that it is not something that is necessarily visible, or that it is genetic, it makes the issue in some senses easier to resolve in that a person can choose not to share that information. And so in that sense, that person can protect himself or herself from discrimination. But it can also be difficult in that it has to do, the way one expresses that can have implications to issues beyond simply an immutable characteristic that a person might have. I grew up in a different era where different values were held about LGBT issues, and you can see here from this line that those values have been evolving for many, many years. There was the Stonewall Uprising that happened in 1969, in which a gay bar was raided by police officers because at that time same-sex sexual activity was unlawful, and there were protests by members of that community who felt that they were being singled out and mistreated by the police, and in many cases they were mistreated by the police. And that led to additional movements within the community, things like Gay Pride Month, gay pride parades, and things along those lines that raised the profile of this community and changed in some senses how this community was viewed. We also see that there has been advertising campaigns and characters in television shows and movies that have shaped the way we view this community, and obviously any community as large as the LGBT community is diverse, having people have all kinds of perspectives and lifestyle situations. You can't really talk about LGBT in the employment law area without talking about the Human Rights Campaign. That is an LGBT affinity group, but we haven't really talked very much about affinity groups here. So you probably can tell from the context that this is a group of individuals, an organization of people who share an affinity or a common purpose, a common focus. And in this case, it is on LGBT issues. Anyway, they have advocated for, in many senses very successfully, for companies to adopt pro-LGBT policies. And in fact, they have a scorecard that they will give companies, and that companies can use that for to advertise that they are supportive of LGBT issues, and that others can use to criticize companies who perhaps are not perceived of as supportive as others would like for them to be. And so they look at those issues and give feedback to corporations and to the general public about where companies are on that continuum. And so this has been, I think, a very effective and savvy campaign to increase the awareness of LGBT issues in the employment situation. There is a law that has been, being considered for many, many years in the Congress, and it is the Employment Non-Discrimination Act, ENDA. And it was intended to provide the same types of Title VII protections that people of various races and religions and ethnicities and genders are entitled to, extend that to sexual orientation. That law is still, or that bill, excuse me, is still no longer law. And because of the recent U.S. Supreme Court case, Bostick and its companion cases, the importance of ENDA probably has declined. That doesn't mean that it won't become law at some future time. But right now, much of what ENDA was intended to accomplish, I believe, has been accomplished through the U.S. Supreme Court. We've talked about companion cases in the past. We talked about it in the Farragher and Eller situation. We have in the Bostock case also two companion cases that give us more clarity about exactly what the U.S. Supreme Court is ruling with respect to LGBT employment law protections. Specifically, what the court said was the word sex in Title VII includes sexual orientation and transgenderism as protected categories. Now, the term sex in the statute, you may recall, is not defined. In fact, there's no legislative history on it. So we really don't know what the initial drafters of the law intended. It's probably pretty safe to bet, though, they did not intend to include sexual orientation or transgenderism. While the U.S. Supreme Court conceded that point, they said that the term sex is the plain meaning of the word sex includes sexual orientation and transgenderism, and so therefore a plain reading of the statute, Title VII, would include these categories. So that is the law of our land, even though the words you won't find the word sexual orientation or transgenderism in Title VII. The U.S. Supreme Court's decision has made that effectively what the term sex means in that context. So let's consider sexual orientation, employment discrimination. Before the Bostock case, my presentation in this area was very brief because federal law did not cover sexual orientation as a protected category, and Texas state law did not cover it. So this is a significant change in the law in our area. So we'll be talking about the Bostock case and how it has reshaped our understanding of sexual orientation law in the employment context. Another really important case is Harris Funeral Homes. And in this case, the U.S. Supreme Court, again, this is a companion case to the Bostock case, interpreted the term sex to include transgender status. So both sexual orientation and transgender status are covered by the term sex. If we go back to LGBT, we can see that, of course, lesbian has to do with sexual orientation, gay has to do with sexual orientation, bisexual has to do with sexual orientation, and transgender has to do with transgenderism. So all of the letters of LGBT are covered under our current, or under these U.S. Supreme Court decisions. Now, as I pointed out, sometimes additional letters are added to LGBT, and some of those particular interpretations or expansions of these concepts may not be covered. So this doesn't mean that every single circumstance relating in some respects to sexuality or gender awareness is necessarily covered, but at this point, all the times that it has become an issue, the court has said yes, it is covered. Even though we have 3 cases to work from, there are so many unanswered questions. Right at this point, we are years away from getting a lot of granularity about exactly what's covered and what's not covered, what employers can do, what protections potential plaintiffs are entitled to. For example, use of pronouns. What are we going to do about that? Let's imagine we have a transgender person who began working for an employer and used male pronouns, now identifies as transgender and would like people to use female pronouns. Does the employer have to use the female pronouns? Do coworkers have to use the female pronouns? What about customers who use the wrong pronouns? There are all kinds of issues with pronouns that we'll have to see as they develop. And then even that's more complicated than just, an on-off switch. For example, some people who are transgender use atypical pronouns. They don't use he, she, him, or, her. They have creative pronouns, sometimes beginning with an X, sometimes differing spellings that have not been historically used in the English language. And so when individuals want to use those pronouns, what is the necessary, if any, necessary response that the employer needs to make? Then we have issues about gender reassignment in the transgender circumstance. A person who identifies as gender A but is anatomically gender B may seek to have some surgical changes or hormonal changes, and this may require a fairly significant expense factor. And if they have insurance through their place of employment, does the insurance policy that employer provides have to cover, for example, breast augmentation if it doesn't cover breast augmentation for women who are choosing to do it for aesthetic reasons, but does cover it for women who are have had a mastectomy because of cancer. So when would it be required? When would it not be required? Even if we weren't talking about health insurance, that person seeking gender reassignment surgery may well need time off for recovery from that surgery. Does that have to be provided? It could be a Family and Medical Leave Act situation, but let's say the employee isn't eligible for FMLA. There is no affirmative action requirement under Title VII sex discrimination. So it seems like it probably wouldn't be required. But we've seen with pregnancy discrimination that employers are required to give to pregnant people the same type of accommodations that they would give to people, say, recovering from a heart attack. And so if an employer were to provide time off for somebody having a heart attack, would that same logic expand to a worker who is having gender reassignment surgery? Perhaps, perhaps not. Probably one of the big questions is dress and appearance codes. If an employer says, well, women need to wear skirts and men need to wear pants, and you have somebody who initially identified as a female and was wearing a skirt and now is identifying as a male, how does that impact the dress code expectations? What if somebody is identifying as non-binary? What would be their dress code expectations? Can they dress both as a man and a female, or do they have to pick one? Or do they need to have a separate dress code that is neither the male nor the female? And it's not just the way the person dresses, but also the makeup and personal grooming choices, how long their hair is. Are they wearing makeup? Are they wearing nail polish? Are they wearing jewelry that is traditionally associated with a particular gender? All of those things can be issues, and navigating that can be tricky. In addition, there can be characteristics that we associate within our culture to a particular gender or to a particular sexual orientation that may not always follow through. For example, we might associate a certain cadence to one's speech pattern to a certain sexual orientation. Many people have that speech pattern. Some are gay and lesbian, some are straight, some don't have it, and some of those people are gay and lesbian, some people are straight. But certain things like that can be associated with a particular category of individual. Is that related to sexual orientation, or is it really a separate issue? And things like affinity group identification. For example, an LGBT member who chooses to wear rainbow-themed clothing or a pin on their lapel or something along those lines. Is that political? Is that supportive? Is that kind of the equivalent of a cross for a religious person? Something that ordinarily employers are required to permit. So there's just lots and lots of questions that we don't know the answer to now, and hopefully over the next few months and years we'll get the answers, but it can present a lot of challenges for employers. So again, when your client is facing these issues in the workplace, obviously if the client is taking the position of we embrace LGBT and we are supportive of it, there may not need to be a lot of reflection. But when you have a client who says, we're not comfortable with this particular issue, and we would like to see what our options are, very likely that's going to require a pretty significant amount of research, because that's going to be a moving target for a while. We won't have a lot of answers. A lot of the answers that are out there right now, you're probably going to find from state law, because several states have had protection for sexual orientation and transgenderism for many years. Wisconsin, California, other states. And so what sometimes happens in these cases is that people pour through those statutes and try to see, well, how have these questions been answered in those communities? Because the idea is, well, maybe we'll get the same answers when it is used to apply to Title VII's sexual orientation and transgender protection. Now, those state law cases are not a perfect guide, though, because obviously the wording in the statute is different, and the statutory interpretation traditions can be different from one state to another. But those are some places to look. Now, in Texas, we haven't had historically a transgender or sexual orientation employment protection, so we don't have statutes within our own jurisdiction to look to, but certainly we can compare and look at other states for some guidance as well. So we're in an uncertain time, but honestly, most of the time the legal professionals face some level of uncertainty. So it's, in a way, it's a very exciting time when we're actually seeing the law develop before our eyes. Let's consider the Bostock case itself. This is considered the most important of the three, so I'll be talking about it, and I will occasionally talk about its companion cases, but this is kind of the main event. So the question is, does Title VII prohibit employment discrimination based upon sexual orientation? And the answer is, very simply put, yes. And all we really need to know about the case is that the plaintiff, Mr. Bostock, is a gay man, and he was terminated, he feels, because he is a gay man. The case is whether that's a lawful thing to happen. And the answer is no, that's not lawful under Title VII. Again, because of that definition, or that meaning, that plain meaning associated with the term sex. This is an important case. You don't need to know the details about Mr. Bostock, where he was working, or any of that kind of thing, but you do need to know this, the holding. So here's the scenario. So Sue is a lesbian. She is subjected to verbal abuse at work because of her sexual orientation. The harassment includes calling her unpleasant names and introducing her to new employees as the resident lesbian. Sue has spoken to her supervisor and nothing has changed. Under these circumstances, Sue may well have a cause of action under Title VII for sex discrimination. And again, when we use the term sex discrimination, probably we could even get it more narrow and say sexual orientation discrimination. Although it's possible that it really is purely sex discrimination, because obviously Sue is a woman. So the employer might be perfectly fine with gay men, but have a problem with gay women. And so therefore, the focus would be on the gender, not necessarily focusing on the sexual orientation. If I were Sue's attorney, I would encourage her to advance kind of both theories in this particular case. This is our other big case. It has kind of a long name. We're just going to call it Harris Funeral Homes. So does Title VII prohibit employment discrimination based upon transgender status? And the answer is yes. In this particular case, you don't need to be an expert in the facts, but I think it's helpful to talk these through. We had someone by the name of Anthony Stevens. Anthony was born with an anatomically male body. At that time, I'm going to use the he pronoun because at that time that's how he was being identified, and insofar as he expressed a preference, that is how he chose to be identified. Anyway, he gained employment with this funeral home, and obviously he was someone whose role was to assist grieving families with funeral planning and the wake and the funeral. As part of his role, as I'm sure all of us who've attended funerals know, that typically the funeral director wears very traditional clothes, dark suits with ties, very kind of conservative, understated, formal clothing. Eventually, Anthony decides to change his name to Amy and to identify as a woman at this point. So going forward, I'm going to try my best to use female pronouns because that is Ms. Stevens' preference at this time. So Stevens, who had a medical diagnosis of gender dysphoria, sought to continue her employment. Again, same person as Anthony in terms of same human being. And she wanted to wear traditional female suits. She was happy wearing traditional clothes, conservative clothes, formal clothes, but she wanted them to be female clothes. So, for example, she would not be wearing a tie. She might be wearing a skirt, or slacks, but it would be a style tailored for women. The employer was not willing to accept Ms. Stevens wearing female clothes in her role as a funeral director, and so it ended her employment. The holding in this case is an employer who fires an individual employee merely for being transgender violates Title VII. So again, you need to know the holding in this case. And you do need to know that about the case. So when employers are considering a situation involving somebody who has a sexual orientation circumstance, yes, we all do, but maybe is in the LGBT community, is it's important to distinguish between the status of being LGBT and sexual orientation from the possibility that there's inappropriate actions or conduct. Employers don't have to put up with inappropriate actions or conduct from straight people or for LGBT people. And so this is not something that has to be put up with, but respecting people's sexual orientation and their status as a member of the LGBT community is something that does need to happen. Action shouldn't be singled out based upon an actor's orientation or sexual identity. We ought not be drawing attention to those issues. And a good lens to think about it is if this person were straight, or if this person was not transgender but had the same gender identity as the physical characteristics he or she had at birth, would we be looking at this situation in a different light? This area of the law, of course, tracks closely with Price Waterhouse. You may recall when we were talking about sex discrimination, we talked about the Hopkins versus Price Waterhouse case, in which a woman, and there was no transgender issues in this case, or sexual orientation issues in the Price Waterhouse case, but in that case, the woman, even though she, as far as I know, was a straight woman who was not transgendered, she had a brusque manner, a manner that we kind of associate on some level with masculine characteristics. And the Supreme Court said, no, if you don't hold it against men who have these characteristics, you can't hold it against women. And so you can see how the sexual orientation idea continues to be kind of in alignment with Price Waterhouse idea. And so we ought to be open to the idea that gender-based stereotypes are not helpful in the employment context and can potentially be violations of Title VII. Let's consider this scenario. So this company has a zero tolerance policy on discrimination and harassment based upon these characteristics. And you can see sexual orientation is on the list. It wouldn't even matter, though, if it weren't on the list, because now it's a protected category. The policy states that employees need to treat each other with respect. Mary is assigned a project with 4 of the coworkers, including Bob, who's an openly gay man. Mary believes that homosexuality is immoral, and acknowledging Bob in any way would be like accepting homosexuality, which goes against her religion. Thus, she refuses to communicate or work with Bob. As a result, her team has difficulty completing its project. Now, Mary is entitled to the protection of her religious beliefs, but that protection does not extend to mistreating her coworkers or failing to do her job. She doesn't have to socialize with Bob outside of work or have lunch with him, but she does need to treat him with dignity and respect. It's unlikely that Mary agrees with every single choice that everybody in the workplace makes. For example, I'm guessing here, because Mary's a made-up person, so I don't know what her religious beliefs are, but I'm guessing Mary also disagrees with extramarital heterosexual sex. Well, let's say that one of these other coworkers, Teresa, is having an affair, an extramarital affair. And maybe another coworker is living with somebody in a romantic relationship without the benefit of marriage. If Mary starts saying, well, I'm going to examine everybody's personal life to see if it's something I approve of, and if I don't, I'm not going to speak with them, you can see how that's not going to be a workable situation. Because eventually you're going to get to the point that, that particular worker, is only goes to church every other Sunday. Well, Mary thinks this person ought to go to church every Sunday. Well, that's enough that Mary won't speak to him or her anymore. So the bottom line is that while Mary is entitled to protection of religious beliefs, that's not going to extend to the point that she gets to pick and choose with whom she works, and that's not going to remove the obligation she has to treat her colleagues with dignity and respect. Again, how we balance this, exactly what we can say to Mary, it may be an evolving target, but the bottom line is that it would be appropriate to direct Mary to work with Bob in the way that she works with anyone else in the workplace. Erica's a lesbian who works as a welder. Erica's coworkers do not know that she's a lesbian. She's frequently subjected to verbal abuse by her male coworkers because they see welding as a man's job, and they obviously know Erica's a woman. Erica's called inappropriate names, and she's shown nude pictures of women on the walls in the workplace. She complains to her supervisor, and she's told, just suck it up. You know, that's just the way that the welders are. So even though she made her complaint, it's ignored, and so eventually Erica quits her job. Under these facts, Erica will have a claim of discrimination due to sexual harassment, and she doesn't have any tangible job action, but certainly sexual harassment is in play here. It doesn't seem that she has sexual orientation discrimination because no one knew about her protected category. And I suppose it's possible, again, because people have stereotypes, and I'm sure, perhaps, I shouldn't say sure, but I wouldn't be surprised if some people thought, well, a woman welder, maybe she is a lesbian. And so that may have been stoking some of these inappropriate interactions. In this case, she happens to be a lesbian, but let's switch up the facts a little bit. Let's say Erica is a heterosexual who just wants to be a welder, and she does her job. She's employed there. It may be that her coworkers think she's a lesbian because they have a stereotype about that. And so they maybe call her not nice names because they think she's a lesbian, or maybe because she's a woman in a man's job. Well, even though Erica actually isn't a lesbian, she could still claim sexual orientation discrimination, kind of like what we saw with the national origin discrimination situation. You may recall that case out of Conroe with the car dealership, where the people who were picking on the employee thought that the employee was an Arab, when in fact the employee was an Indian. And the fact that they were mistaken about their views and the reason that they were discriminating doesn't change the fact that they were discriminating. And so the victim of the discrimination was entitled to advance his claim. And I think the same would be the case for Erica if she were heterosexual but was confused, or people thought she was a lesbian or transgender for that matter. Margot is a homosexual. She works in a Texas-based firm. Though Margot does not break her employer's dress code, her supervisor constantly tells her she should dress more femininely and adopt a more ladylike behavior. After several failed attempts to change Margot's behavior, the firm terminates her. Margot files a claim of discrimination. In this case, Margot's behavior or her claim is going to be based upon a Price Waterhouse type claim. She certainly can raise sexual orientation, or she can just talk about gender discrimination. She doesn't fit this particular employer's idea of how a woman ought to act. Let's change this up for a second, though, and let's say that the employer has a dress code that requires women to wear dresses. Margot is a homosexual. She would prefer to wear slacks. Under those circumstances, at least as how the law exists today, the employer can require that she wear a dress. Just the fact that she's a homosexual doesn't somehow mean that she can't wear a dress. Under those circumstances, assuming that there is no transgender issue, and assuming all the law that we have about dress codes doesn't change, then Margot could be dismissed under that basis. Let's consider the next scenario. So Larry is an African-American gay man, and he works on an assembly line. While he's working, he talks with his co-workers about some of his intimate sexual experiences. These coworkers explained to the supervisor, and Larry's asked not to discuss his personal life at work. But Larry continues to talk about these activities, and his employment is ended. Now, this could be an example of sexual harassment. The coworkers have lodged a complaint about hostile work environment. Larry was counseled about it, and he continues it. So there may not be any claims, but let me present to you a couple of wrinkles that could raise a claim. For example, let's assume that the other workers also share intimate stories of their sexual lives, but they're all heterosexual. And the members of this group aren't troubled when there are heterosexual stories like that, but they are troubled when there are homosexual stories about that. Well, that very likely will be an example of gender discrimination. And so if the other fellows or women for that matter, were engaged in sharing those stories, they weren't counseled, but Larry was and was ultimately discharged, it does sound like it could be sexual orientation discrimination. Let's put another level to it, and that is, let's say that there were other men and women in the area who were not African American who shared stories about their sexual activities. And let's say they weren't counseled for that, or they weren't terminated for it. Maybe they were counseled, but they weren't terminated for it after the second incident. Larry was. Well, then now Larry may have a claim of race discrimination because he was treated differently because of his race. So again, there can be lots of different dynamics. It could even be the case that this employer has no problem with African American men and has no problem with gay men, but it has a problem with African American gay men. In other words, this would fall into the sex plus category. And then we talked about in the Phillips case, Phillips versus Martin Marietta, where an employer had no trouble hiring women and had no trouble hiring men with young children, but refused to hire women with young children. And that type of discrimination was called sex plus. Well, you could have it here too, or race plus for that matter. They're fine with African Americans, they're fine with gays, they're just not fine when somebody happens to fit both categories. Now that can be hard to prove, obviously, unless there's some kind of smoking gun, because we're kind of getting quite granular. An employment place may only have one African American gay man, and so it may be hard to know exactly what category of discrimination, if any, is happening. Let's consider Ryan's situation. He is a homosexual man. He was recently made the manager, and thereafter he demotes all the men in his department, and one of the demoted men, Bob, files a claim of gender discrimination against Ryan on the grounds that Ryan demoted only men and not women. And under those circumstances, Bob would have a valid claim, assuming that Ryan wasn't able to prove that the men's performance was really the reason for that. Now, obviously, in this story, I'm assuming there were women in the department who weren't demoted. As you can see in this story, really, Ryan's sexual orientation isn't relevant to the story. The story is pretty much the same, even if we were to remove his sexual orientation from the story. But that's what I'm trying to point out is, in this example, sometimes sexual orientation is just a background fact. It's not necessarily what's driving the particular story. And identifying or focusing on that fact, in some sense, can be discriminatory in and of itself because a person is more, obviously, than their sexual orientation. Ethan operates a clothing store that markets his products to lesbians. Bob applies for a job. So Bob is a male. He has extensive experience in the field of apparel retailing. Ethan rejects Bob, though, because the company is looking for qualified lesbians to fill the position. The idea Ethan has is, well, lesbians are going to want to buy clothes from other lesbians. And lesbians can wear the clothing that we're selling and can therefore kind of make a fashion statement as well. But you don't have to be a woman to sell women's clothing. You don't have to be a man to sell men's clothing. Being a lesbian is not a BFOQ to be in the garment business. And so Bob could successfully claim gender discrimination under these circumstances. we've been talking about private employment at this time, and of course, if the particular employee is employed by a governmental agency, he or she would have the same Title VII rights that private employees have. But if the employee is employed by some kind of government entity, that employee is going to have additional protections. They can include both the First, the Fifth, and the 14th Amendment, as well as kind of that in that penumbra, that right to privacy. And so we haven't seen yet kind of what the full flavor of these protections will be, but it's safe to say the case law will continue to develop in this area. So we're going to look in two cases where there's public employment. This is a public school here, and this person is a public employee. So we have Carrie. Carrie's a lesbian. She's a school teacher. A student's mom finds out that Carrie is a lesbian and complains. The school removes Carrie from the classroom. Under these circumstances, Carrie can file suit under the Equal Protection Clause of the U.S. Constitution, again, because she works for a public school, as well as under Title VII. Now, if Carrie worked in a private school, she wouldn't have the Equal Pay Act claim. She may or may not have the Title VII claim. If it's a private non-religious school, then she will have the Title VII claim. If it's a religious school, very possibly her role will be considered to some extent ministerial, and so the school would be able to say, well, if this isn't consistent with their belief system, their religious belief system, then they could say that Carrie could not teach in their school. Let's consider the scenario of Larry. Larry's a public employee. He was subject to discrimination at work after a few coworkers learned that he is gay. If he files a sexual orientation discrimination claim, again, he would have the Equal Protection Clause argument and Title VII or both. And obviously, I think Larry's best course of action, just like Carrie's best course of action, would be to sue under both theories. So now we've completed our sexual orientation employment discrimination. We're going to touch just briefly on the topic of same-sex sexual harassment. We've talked about this mainly about the Untitled case because we don't have any new cases to talk about yet. But as we talked about in the sexual harassment section, the big case here is the Untitled case, and same-sex sexual harassment is prohibited under Untitled. I'm going to be honest with you. Untitled, if you read the opinion, it's very obvious that the U.S. Supreme Court at that time thought that sexual orientation was not a protected category under Title VII. We know under Bostock that it is protected. So much of the language in Untitled is not consistent with the premise of Bostock. So it's not clear right now how much of the Untitled decision actually survives. We'll have to see how those fit together. So I'm a little bit skeptical about focusing too much upon the Untitled decision. It is my opinion at this point that we're likely to find that much of its hesitancy in the area of same-sex sexual harassment is no longer warranted. Let's consider some scenarios here. So we have Paul. He works in a gym as a secretary. His coworkers like to tease him, calling him a pretty man because he doesn't like to lift weights, and they call him Paula, even though he's not transgender. They sometimes imitate the way he walks and behaves and tell him he acts like a girl. Apparently, they perceive him as effeminate, but again, there is no transgender issue here. Paul is very disturbed because of the way he's treated at work. Paul may have a valid claim of under Title VII because it prohibits same-gender sexual harassment, if it really is sexual harassment. Sexual orientation, Paul's sexual orientation, which I haven't shared at this point, may or may not be relevant to this claim. If Paul is gay, then he can obviously assert a claim under Title VII for sex discrimination. If Paul is straight, but his coworkers think he's gay, again, it's like the Conroe car dealership story. Paul would still have a claim, even though, because he's been discriminated against, even if it's based upon an incorrect understanding. Let's consider the next scenario. Bob is a waiter, and he's also studying fashion design. The other waiters ridicule his field of study, saying, "Real men don't use sewing machines." They call him a punk, and they keep targeting their jokes at him. They even attempt to pull his shirt off once. This happens on a regular basis, and naturally, Bob is pretty upset about it. Under these circumstances, he has been subject to same-sex sexual harassment under Title VII. And again, if Bob is straight, he could still have a claim for sexual orientation discrimination because it appears that his coworkers think that he's gay. If Bob actually is gay, then that would be an additional basis for the claim as well. So those are two scenarios. Let's look at two more. Bob is being subjected to severe, pervasive, and unwelcome sexual harassing behavior from a supervisor who happens to be a man, Greg. Bob can bring a successful claim against Greg for sexual harassment under Title VII, again, because same-sex or same-gender sexual orientation is prohibited. In this story, Bob's sexual orientation is irrelevant. It doesn't matter if he's also gay. He doesn't want to be sexually harassed by somebody who's male. Just because he's gay doesn't mean that he's interested in every single person in every single circumstance. If Bob is straight, again, he would also have a claim under these circumstances. Let's consider the next scenario. So Ross is a homosexual male. He refuses to award Bob a heterosexual, a well-deserved promotion at work unless Bob agrees to be sexually intimate with him. Bob refuses and is not promoted. Under these circumstances, this is a quid pro quo sexual harassment case. And so Bob can proceed under Title VII. He could have proceeded under Title VII even before the Bostock case, certainly. But just like homosexuals are protected by Bostock, heterosexuals will be protected by Bostock as well. Here is the LGLA case. I've edited it somewhat to reflect I've edited the information I'm providing to somewhat reflect the Bostock changes. So does Title VII apply to same-sex sexual harassment? And the answer is an unambiguous yes. In this case, Joseph Onkale alleged that he was sexually harassed by his male co-workers at work. Again, this is that offshore oil rig. The U.S. Supreme Court rejected a per se rule that same-sex harassment was prohibited under Title VII. Again, I'm thinking this isn't going to survive after Bostock. So put a little question mark there. The court held that harassment is a type of discrimination based upon a protected characteristic. That's good law. The court held that while Title VII does not prohibit all verbal or physical harassment in the workplace, it does bar all forms of discrimination based upon sex. That also sounds like it's good law. Such discrimination, whether motivated by sexual desire or not, is actionable so long as it places its victim in an objectively disadvantageous working condition, regardless of the victim's gender. That's also going to survive. Again, as you read this case or review the Onkale case, you'll see that the court said, yeah, you can prove same-sex sexual harassment, but it's pretty clear it's hard to do. It's harder to prove that than the traditional opposite sex sexual harassment. My guess, and it's just a guess at this point, but my guess is after Bostock, that distinction that Onkale established is no longer going to be the law. Now let's consider the gender identity employment discrimination category. And this is the one that probably has the most questions. So I'm not going to be able to do too deep of a dive just because we don't know the answers at this point. So let's consider the two terms that we've been talking about. One is sexual identity or gender identity and sexual orientation. It's easy to conflate these or confuse these. Gender identity involves self-identification with a particular gender. So imagine that Bob is born anatomically male, identifies as a female. We don't know who Bob is romantically attracted to. Bob may be romantically attracted to men, or Bob may be romantically attracted to women, or Bob may be romantically attracted to both men and women. So gender identity is a separate concept from sexual orientation. Similarly, let's imagine Susan is anatomically female. She identifies as female, but she is attracted romantically to females. her gender identity is not transgender. Her identity is the gender to which she was anatomically born. Her sexual orientation is what is different. So it would be a mistake to confuse or confuse those particular types of concepts. They are definitely separate. These are some important terms to think about and be familiar with. If you haven't added these to your Quizlet, I recommend that you do so. Gender dysphoria is a medically recognized condition that affects transgender individuals. This is when a person is emotionally uncomfortable, upset. Upset sounds like a trivial word, but is suffering in some level because the person's physical body, the anatomy, the sexual anatomy of this person is different than the person's gender identity. So again, Bob is born anatomically male. Bob identifies as a woman. Bob is uncomfortable with his body because it doesn't match his gender identity of woman. Under those circumstances, Bob would have gender dysphoria. So gender identity is how one identifies for male-female purposes. And again, this can include a transgender identification. It is possible for people to have what is oftentimes called a fluid or non-binary gender identity. In that case, a person might sometimes identify as one gender and then at other times identify as the other gender. Or perhaps they don't identify as either gender. Or perhaps they identify as another category of gender. And so there can be lots of different shades within this perspective. So it's not just a male-female issue necessarily. Intersex individuals are those individuals who are born with both male and female genitalia. An old-fashioned term which is not preferred and is not considered sensitive is hermaphrodites. I'm using it simply so that you, if you've heard of this term, you know that we shouldn't use this term, and that intersexed is the appropriate term to use now. These individuals are not transgender because, again, well, as we'll see in this definition, there isn't a difference between their identity and their anatomy. This is another term to add to your Quizlet. Let's look at transgender. Someone whose physical characteristics, meaning their anatomy, do not match how they identify in terms of gender. Many transgender people choose to undergo gender reassignment surgery or hormonal treatments. Many don't choose to for a variety of reasons. Again, that's really no one's business other than the individual. But whether the person chooses to have surgery or not isn't a factor in whether they are a transgender or not. And again, here's another vocabulary term. And our final vocabulary term on this slide is gender or sexual reassignment surgery. And these are the surgeries that some transgender individuals and also intersexed individuals might undergo so that the body matches the gender identity of that person. For example, somebody who was born anatomically male may choose to have breast enhancement surgery so that they can look more female. Or they may have other, I'm not going to go into specifics, but other genitalia surgery to create a body more in line with their gender identity. And there can be other things too that are more subtle than surgery. For example, electrolysis to remove body and facial hair. I think there's some certain surgeries that can be done on the voice that can change the pitch of the voice. The safest thing for an employer to do when you're dealing with gender identity situations is to treat the employee consistently and in the way that the employee chooses to present his or her identity. That's the safest path, and the one that, as a general rule, I would encourage you to recommend your clients to adopt. As we said before, gender identity is a protected category under Title VII. Now, I do need to flag this one issue because it's going to be interesting to see how the case law develops with respect to this. But the Americans with Disabilities Act expressly excludes gender identity, transgenderism, and sexual orientation from protection under the Americans with Disabilities Act. They are not considered disabilities, and they are not eligible for reasonable accommodation. Sex discrimination under Title VII is not entitled to any kind of reasonable accommodation. So it's an interesting area that we are in from a legal standpoint. Exactly how some of these pieces will fit together, we'll have to see. Let's consider this scenario. Charles had gender reassignment surgery and became Charlene, a person who identifies as female. Prior to the surgery, she was a night security supervisor in an industrial park. When Charlene reports to work after the surgery, the employer reassigned Charlene to the day shift because the employer thinks the conditions are too dangerous for a woman working at night. If Charlene had wanted the change, there isn't a problem. If Charlene's happy with the change. But if she's not happy with the change, perhaps she's going to lose her late night shift differential, then she can allege gender discrimination. Again, this wouldn't be so much because she's transgender, but because she is now being treated as a woman, but being treated in a discriminatory way. Now let's say, though, let me switch up the facts. Let's say Charlene is happy to be relocated to the day shift, but as a result of her relocation to the day shift, a male who is currently on the day shift is reassigned to the night shift. Well, that male, let's assume, didn't want the shift change. He could have a claim. He could say, wait a second, why am I being moved to the night shift simply because I'm a man? Why does the woman get to make a change in her shift? And so there could be a gender discrimination claim for the person who's swapping with Charlene. At this point, we've covered sexual orientation, employment discrimination, same-sex sexual harassment, and gender identity employment discrimination. Here are some things to keep in mind as you navigate these areas. This is an area of the law that is new and it's controversial, and many of our employers in this state are not going to be comfortable with this, are going to have philosophical disagreements with it, and they are not necessarily going to be apprised about this. So there's going to be an opportunity that legal professionals in this area will have to educate both managers and employees. Again, many issues are going to remain in flux, and so it's best to take a cautious approach to let the client know various options and the various risks of the various options. Employers' corporate policies are going to play an important role. Is a senior management supportive of LGBT employees? And so that will need to be something that is emphasized. It's not just what the manual says, it's how people are actually treated. Does everyone feel respected? Does everyone feel heard, whether they're gay or straight, transgender or not, religious or not? These are very emotional issues. These are very sensitive issues, and they can be very divisive, and so it requires sensitive management to navigate through these. As always, hire based only upon relevant work-related criteria. Keep inquiries about applicants' personal lives to a minimum and only when they're relevant. And I would extend this to employees. There's really no need that we have to know what's going on in a person's personal life. Have a policy that ensures all employees are going to be treated with respect and dignity in the workplace. The policy should make sure that everyone is protected from unsolicited negative statements and questions about whatever that characteristic is, unless it's work-related. As this area of the law develops, be sure to stay abreast of what the new changes are, because there will be changes. And I'm sure there are things I said today that in 5 years we'll say, oh, River got that one wrong. And that's okay. We don't know what the answers are. We can just kind of make it our best guess right now. I hope that this information has been helpful to you. Again, if you have any questions, feel free to stop by and we can chat about it in more detail. Thank you for your attention and have a wonderful day. Take care.